We're joined by the CCMA Director, Cameron Morajane, to discuss this further. Cameron, good evening and thanks for your time tonight. Certainly, as you get ready to reopen your doors, you've already been able to calculate some of the figures in terms of what you expect as you restart your processes. And the picture's not looking good on the front of retrenchments and especially small business. But let's begin with the scale of retrenchments.
Thank you very much, Kathy, for having us tonight. It is indeed a night before we reopen. We are back. We have been there. The only thing that we did not have was the walk-ins and the actual set-downs. We used the web-based hearings process. So yes, our numbers have grown. I must say also that the biggest number of our referrals comes from people who walk into our offices. So effective from tomorrow, the numbers that I'm about to give you, we expect them to change quite significantly. Just purely on the large-scale dismissals, we're sitting at about 33 of those, which is the large-scale one. And the small-scale one, which involves one employee, is about 178. And when you're looking at the large-scale ones, which is the 33 I referred to, it does not necessarily mean that it's 33 employees. You'll find that one has about 50 or 40, sometimes it's thousands of employees who are part of that process. So that's exactly what we're expecting now, effective from tomorrow, that the numbers will increase significantly more than the number that I just read now. So we are talking about different types of businesses, different sectors that are involved, and we're still now calculating exactly which sectors are leading. Usually it's mining, and that leads in that. So that's what we're expecting effective from tomorrow.
It's interesting because in part of your figures, you've also highlighted the extent to which the small business enterprises have been just obliterated in terms of job losses, and that in itself could, of course, have a much higher contribution to the scale of people that are going to be unemployed.
That's correct. It's not only a source of employment in South Africa, as you know, but now because of the restrictions and especially level 5 of the lockdown, it has been hardest hit by that. So we expect that it's going to be the biggest contributor into our numbers. But we have our commissioners ready to facilitate these retrenchments, and I think we will do our best under very difficult circumstances. But I must also say that the numbers are not only limited to the retrenchments. There's different types of cases that we're expecting. There's those that came before the lockdown. There's those that came during the lockdown. So we have prepared all our troops on the ground for us to be able to deal with that, which will probably cause us to also go for extended hours in order for us to be able to meet the demand and the backlog, because we have not been able to set matters down at our offices. So we've got other very interesting options that we're going to use in dealing with these matters, and I can elaborate.
Sure. Sure. What is going to be the role of force majeure when it comes to trying to mediate between these organizations that, of course, are just declaring disaster and saying they simply cannot afford to keep on the staff, and, of course, on the other hand, people who genuinely need these jobs?
The principle of force majeure, as you understand, is one of those traditional legal concepts which effectively means that the operations of the enterprise are actually affected by a force which is beyond the control, like a natural disaster. And in our situation, it's a pretty different, because what we've seen is that the argument of force majeure has been used both in the lawfulness sense and also in the fairness sense. And what we are expecting is that as a result of the force majeure principle and its application, it's going to be an issue that's going to be used as an argument. But what is simple, the plain way of dealing with that, is to understand what a Section 189 process is. The bottom line is that it is that type of a dismissal which is purely on operational grounds, which is a no-fault dismissal. A force majeure, it is not the fault of the employee, it's not the fault of the enterprise. There was a lockdown, there's a disaster management, and statutes and regulations have been issued which has caused the lockdown. So as a result of that, it has stopped economic activity, which then causes complications on the operational side, particularly in as far as the economics or the finances of the company is concerned. So when such a matter is brought, in the face of law, you are talking about an operational requirement because there's been no money or financial streams coming in. As a result, the company can't afford. But we are not dealing with it directly as a force majeure, but it is a causation, a nexus that has caused the financial strain, and our focus, therefore, is 189. For example, you also have others who are claiming that we have been forced to take leave because of the same principle, and others saying we have been forced to work less as a result of the same principle. There's also remote working. There's unlawful deductions that have been made from salaries. There are those that have not received salaries at all, but the enterprise is still alive. There are others who have applied for the COVID-19 funding. There's others who applied for TERS and normal, which is about companies which are in distress caused as a result of COVID-19. What is important to distinguish is that when we're talking about the force majeure, it is the cause for us to activate disaster management and the regulations, but it is not the one that has destroyed the enterprises, because the legal argument must be quite sane and clarified. Because if it was a direct force majeure, it will mean that the disaster has destroyed enterprises. As a result, no one is able to operate or to live, but that's not the real cause. The real cause is that the law has been activated and regulations were issued as a result of the force majeure. But the basis of the challenge will be the enterprise is not operating because of finances, is not operating because they have been shut down. The ultimate cause, the end result, may be because of the force majeure principle.
So does this then make it easier or more difficult going into these mediation processes?
It makes it very difficult. Let me give a very practical example. There will be enterprises who are completely obliterated because of financial strain. So if you come to this process and you facilitate, at the very least, you need to have some leverage or some room to move to be able to persuade parties to agree to some kind of an outcome. What makes it impossible is that if the enterprise has been obliterated, you are unable to enter into any form of settlement other than certain statutory payments that must be made. Sometimes when an enterprise is completely obliterated, and if the matter, for example, is unfair dismissal referral because of operational requirements or retrenchments, if you make an award that says the process has been unfair, therefore employees must go back to work, but there is no enterprise that exists that they must go back work to. One of the difficulties that we've had is when you have to deal with a situation where the enterprise is already dead, because there's no respondent that can come to the process. Even if they come, you have a default award, then that award is unenforceable. In law, it is correct, but practicality is very important. You see, one of the things that we do is that an award is an award only if it is able or have the ability of being enforced. That's what we call jurisdiction. But if finances or the existence of the entity is non-existent, we can make as many awards as you want, but no one is able to receive and enforce it. Yes, in answering the question directly, it makes it very difficult when there's no money or the entity has been destroyed.
What recourse will employees who during this time perhaps have not been completely let go but have had to take significant salary cuts, what would those employees need to show before the Commission to be able to justify why they're still fighting for those monies, especially if they believe that the company would be in a place to pay out those monies, even if it does mean that it's denting their profits significantly?
One thing that we had to deal with, Kathy, very interestingly during the lockdown itself, was circumstances where an employee will receive an SMS that says, we're not going to pay you next week, or get an SMS that in 1 week's time the company is closing down, as a result of which we won't be able to pay you. The bottom line that is a money dispute. A money dispute follows the same process of referral coming to the CCMA. You fill in the form either electronically or you walk into our offices, subject, of course, to the discipline process that we put in place, and you claim in your referral form that my company, they ought to have paid me 1,000 rand at the end of the week or the end of the month. They did not pay me. Will you please make them pay? We then attempt to conciliate. Usually we do so. There's a process we're busy with now. We call it the pre-conciliation process, which means that the commissioner can phone both parties without them having to come to the office and trying to settle the dispute between the parties, because money disputes are easy to deal with, because it's about one thing. This is what I'm supposed to be paid. this is my pay slip, and then the employer did not pay when they ought to have paid. So the employer will have to show that, yes, indeed, I did not pay, and these are the reasons. But what is important is not about affordability. It's about the legal obligation to pay the salary of the employee. So normally in circumstances of a operational requirement dispute, you are able to request for disclosure of financial statements in order to justify the unaffordability state of the enterprise. But in terms of our rules of the CCMA, even if it's not a retrenchment process, it is a normal arbitration process. In terms of Rule 29, you are able to ask the commissioner to issue a directive to the employer to disclose certain information, which may include the financial statement to show that in fact you are unable to pay salaries because you don't have money. But the fact that you are impecunious, it does not mean that your obligation to pay has been dispensed with. The responsibility remains. In some cases, even if there's inability to pay, it may end up in process of attachment and execution in order to realize those important financial obligations. So all it needs is just the proof of payment, and the issue of ability does not arise. It may arise if at the end of the day you have not been able to pay. In cases where there's an award made that we have to pay, it goes to the sheriff to attach in order to get those monies. But that is the very last resort. We always try our best to make sure that we make some kind of an arrangement between the parties so that we can have an amicable resolution, especially if the enterprise is still existing, because the most important thing in resolving a dispute is not having a winner and a loser. You have to try to find a balance of interest between the enterprise and the employee so that post the process of resolution of the dispute, that the relationship continues, a healthy relationship continues, if they still have to deal with each other. It's different where the employee has been dismissed, because there it's about the battle lines have been drawn. You pay my money or else. That's a different circumstance.
So just very briefly, if you can, before I let you go, there are people who had matters before the CCMA, before the lockdown was enforced. So how is the order of these cases going to work now? What will you be giving priority to, very briefly?
Briefly, it's a matter. This is a matter of first come, first serve, because it would be very unfair for us to give priority to cases that were referred during COVID-19 when there's been matters referred before lockdown. So it will follow that order from before the lockdown all the way up to during the lockdown and post-lockdown. So that's the order we're going to. But what we're going to do is that those matters that are easy to resolve, like your money disputes, your minimum wage dispute, we've got commissioners that will deal with that in terms of the pre-conciliations and dispense with that. And the more complex ones, they'll go through the normal process of arbitration. But every case is going to be a priority, but those that come first will be given the first priority.